All right, you can admit.
Good morning, everybody.
Morning.
Give everybody a few moments while everybody's signing on with their audio. And for anyone joining, if you could mute yourself. Just gonna give a few more moments while everybody's in. Good morning, everybody.
Good morning.
We have a few more joining. All right, good morning and welcome everyone to Get Real with Attorney Martinez. Today's topic is neighbors driving you crazy. Learn all about nuisance laws, easements, and trespassing. This is an informal roundtable. After the topic presentation, we will open up for question and answers on this or any real estate topics that you have questions about. If anyone experiences freezing during this meeting, try disabling your video to see if that helps. I am Jennifer Canizzo, paralegal with Martinez Law. And then we have a few of our team members who would like to introduce themselves. Attorney Love.
Hi, good morning. I'm Tiffany Love. I'm a partner here at Martinez Law, and welcome this morning. I think we're going to have a great discussion. So pleasure to meet everyone that's joining us today. I'm going to turn it over to Tiffany Thornton.
Good morning, everyone. I'm Tiffany Thornton. I'm an associate attorney here at Martinez Law. Nice to see you all this morning, and I hope you all enjoy today's topic.
Stephanie.
Stephanie, did you want to go ahead and introduce yourself? And then I think that's all we have on.
I was trying to see if I could quietly get out of it, but clearly not. Hi, everyone. My name is Stephanie Gibson. I am the COO with Martinez Law.
All right, and I think that's all of the team members. Did we miss anyone?
Javier is on. Javier, did you want to introduce yourself? If not, she's being shy or maybe on a call, but Javier McCool is our legal assistant here at Martinez Law.
All right, and it looks like that covers everybody. Thank you so much for joining us this morning. If you don't know me, my name is Cristen Martinez. I founded the law firm back in 2015 as a full-service real estate law firm locally in Wesley Chapel. So we have actually recently expanded with the addition of Attorney Love last year into handling HOA and condo association representation as general counsel. So any real estate need that you have, we would be happy to help you. If we can't help you, we have enough connections, I think, in the community to be able to get you to the person that you need. But you know, one of the goals that I had when I started the firm was to educate the community, educate real estate professionals on different topics in the law that you may come across in your day-to-day business, or you know, your clients may come across, and to really help people educate themselves so that you can be protected from a legal standpoint and hopefully not have to call our office for any sort of litigation services. So these monthly events is one way that we're able to do that. The the main purpose of these events is to be kind of an informal roundtable discussion. So as you have questions, feel free to type them into the chat. I will be going into the topic here very shortly, but as you have questions throughout, feel free to put those in the chat. And then once I formally open it up for Q&A, if you would like to, verbally ask your questions as well, feel free to unmute yourself and we can take those questions as well. Please don't be shy. This is your opportunity to get your questions answered and not have to pay a consultation fee or anything formal like that. And so hopefully you will utilize this, but I'm going to go ahead and jump into today's topic. Before I do that, we are only offering today's event by Zoom. That is because I am in California right now. It is bright and early, 7:30 in the morning. So starting next month, we will be offering that in-person event as well, or that in-person option as well. So I hope to see you all in person next month. If not, we will be also having the Zoom option, but this month we are all here by Zoom because of my travel schedule. So the topic that we're talking about today is all about neighbor disputes. These issues, they're not the most common issues that arise in my practice, but they do come up very regularly. And the perception that a lot of people have is not really accurate, especially when it comes to nuisance laws. Basically, my neighbor is annoying me. I don't like what they're doing. So I thought it would be a good topic to address, to kind of address some of the misconceptions that I think are out there. And of course, answer any questions that you may have on the topic. So with the topic of, neighbors driving you crazy, I broke that down into 3 subtopics that we're going to discuss today. The first one is going to be trespass issues. The second one is going to be nuisance issues. And then finally, we will wrap up talking about easements. There are probably many other ways that neighbors could annoy each other or disturb each other, but these are the 3 main categories from a legal perspective where there is some legal relief offered. So we'll start with trespass, and I'll give you the definition of trespass to start, and then we'll kind of break it down a little bit. So the legal definition is a person who, without being authorized, licensed, or invited, willfully enters upon or remains on any property. So what we are talking about here is real property, real estate. The statute actually breaks it down into 2 categories. So if the trespass is into an actual structure, so that could be a home, that could be a motor vehicle, the actual act of entering into that property is enough to constitute an illegal trespass. If it's not a structure, so if they are, if somebody is trespassing onto real property, but they're just in the yard, for example, the owner must give notice to that person, or they must close off the property in some way before a trespass can occur. So for example, a fenced in yard, that's not considered a structure, but if somebody entered in through a fence, that would constitute trespass. Also, a no trespassing sign would work, or a private property sign. That is enough to notify the person that is committing the act of trespass, so that it constitutes an actual illegal trespass. So if we're talking about entering into a structure or motor vehicle, there's no notification. You don't need to close off the area any more than it already is closed off because it is a structure for that trespass to have occurred. If it is not a structure, the owner must either close off the area or give notice to the person committing that act of trespass before it constitutes the defined term of trespass under Florida law. So there are 2, we'll call them remedies, that are available for trespass. The first one, it's really not a remedy, but trespass is a criminal offense. So that is not something that a private person could pursue against the offending person, but that conduct could be reported to the local authorities, to the state attorney, and then they would make the decision whether to prosecute or not. But by statute, trespass is a criminal offense. There's also a civil remedy for trespass, which is where my office would come in which is what we're going to be focusing on for purposes of today. So if you or your client or somebody you know has been dealing with issues of trespass by some other person, you have two options as far as a civil remedy would go. The first one would be monetary damages. Now, monetary damages in this area, like we're going to talk about in the next two topics as well, they're going to be somewhat speculative. Unless someone is coming on your property and damaging your property and you can quantify that damage, it's going to be a pretty difficult number to quantify. If somebody's, coming into your fenced in backyard and peeping through your window and harassing you in that way, that's absolutely trespass. You are entitled to a remedy, but what is the monetary loss that you've suffered? So one issue that comes up with these types of claims is being able to quantify the damage when we're talking about monetary damages. When it comes to trespass, though, in my opinion, the more important remedy is what's called injunctive relief. So what injunctive relief is instead of requesting a dollar amount or money damages, you are requesting a court or a judge or a jury to force the other person to either do something or stop doing something. In this case, to stop doing something. So you could file a lawsuit for trespass against the offending person. You could ask for money damages, and you could also ask the court to enter an order prohibiting that person from continuing the conduct that constitutes trespass. So those are the two types of remedies on the civil side that are available for trespass. Some examples of trespass would be, using another person's property for access to your property without a legal easement. That would be a trespass situation. What comes up pretty often in our practice, and I'm sure in Tiffany's practice as well with the association work, is if you have tree branches or landscaping that is intruding onto your neighbor's yard, or your neighbor is cutting their trees and they cut a limb or a branch or a portion of your trees or landscaping, that would be considered a trespass as well. Those damages are a little bit more easy to quantify in that case. And then the obvious one, just coming onto somebody else's property uninvited. The important takeaway here for trespass, and we'll contrast that with nuisance, which we'll talk about next, is that a trespass has to be a physical invasion of land. So again, those examples that I just went through, there's millions of other examples, but the takeaway is a physical invasion of land. If it's a structure or motor vehicle, that's all you need. If it's not a structure, the requirement is that you either close off the area or you give notice to the person. So that is trespass. And let me just make sure that I'm keeping an eye on the chat. As you have questions, like I said, make sure to go ahead and put those in the chat and I will address them as they come in. But with that, we will go ahead and move on to nuisance law. So I think as far as misconceptions go, most of them fall into this category of nuisance. That also is because, in my opinion, nuisance law is a very gray area. It's a more subjective standard as far as what constitutes a nuisance. And there's just a lot of leeway, I guess, that judges have when they are deciding on these cases and deciding what constitutes a nuisance and what doesn't. So again, I'll go ahead and give you the definition, and then we will break that down and talk about some remedies when it comes to nuisance. So the legal definition of a nuisance in this context of neighbor disputes is both a substantial and unreasonable interference with another's use or enjoyment of property. So in general, the law here in Florida is that a property owner cannot use their property in a manner that interferes with another person's right to use and enjoy their property. This is kind of a balancing act because as the owner of property, you do have the right to use your property however you want, but that has to be balanced with, you can't use it in a way that's going to substantially and unreasonably interfere with somebody else's use of their property. So you're probably confused at this point, but hopefully I'll fix that. So the key takeaway here in the definition is it must be unreasonable and substantial. Now, what do those words mean? They probably mean something very different to me versus, Stephanie or Tiffany. So that's where the gray area comes in when we're talking about nuisance law. But in general, a minor annoyance is not enough. So if your neighbor wakes up every single morning and at 9 o'clock in the morning, they sit on their porch and they play, music while they're having their coffee, that's annoying to you. And they do that for 30 minutes every morning. That's probably in the category of a minor annoyance. That's not going to rise to that substantial and unreasonable level. Now, time of day is important. The volume of the music is important. Maybe the language used in the music is important. So if they're doing this at 3 a.m. at full blast for 3 hours every single night, that may be a different story. So what the courts use in this area of law is our friend in the legal world, the reasonable person test. So a reasonable person using their property in a reasonable manner must find the conduct offensive, annoying, and inconvenient. So what that means is if you are especially sensitive to some sort of annoyance, you're not that reasonable person standard that the law is going to use when determining whether something constitutes a nuisance. So let's say that, we'll go back to our music example. Let's say that I hate rap music. I find, curse words very offensive. I am very overly sensitive to vulgar rap music with cuss words in it. I can't stand it. It makes me have panic attacks. It gives me anxiety. It gives me this visceral reaction anytime I hear it. And my neighbor is waking up at 9 a.m. and having their coffee and playing 30 minutes of rap music at a reasonable volume every single morning. To me, that is substantial. That is way more than a minor annoyance because I'm subjected to this music that I find, intolerable every single morning of my life. But to a reasonable person, it's probably in that minor annoyance category. So we have to use the reasonable person test in determining whether the interference is both substantial and unreasonable. Again, subjective standard. The law, I think, has done as good of a job as possible to make this as objective of the standard as possible, but it's not that possible in this area of law. And so we are stuck with both the substantial and unreasonable standard as well as the reasonable person test. It has to be substantial and unreasonable to a reasonable person, not a person that is overly sensitive to a specific type of nuisance or annoyance. So that is nuisance law. Let me make sure there are no questions coming in on that. Let's go ahead and talk about some remedies when it comes to nuisance laws. So nuisance is not a criminal offense like we saw with trespass, but you do have the same two remedies on the civil side that we had with trespass. So you have the monetary damages, which again, I think are even more problematic probably in this area of nuisance because, how do you quantify your level of annoyance? And also, the damages are going to be very speculative. Typically, when you sue someone for damages, that is actual out-of-pocket costs that you've suffered. Here, we don't have that. There are ways that we can quantify these damages, but it's, not as simple as you breached a contract, you didn't pay me what you owed me. Here's, documentation proving that you haven't made payment. It's not as simple as that. So the litigation in this area is usually a lot more involved, which means it's a lot more expensive, takes a longer time when it comes to the damages side of things. The second remedy, as we saw with trespass for nuisance, is also going to be the injunctive relief. That's also going to be the most common remedy in this area because at the end of the day, the person just wants the conduct to stop. They probably wouldn't mind having some money, but the big goal here is to get the person to stop, and that's what injunctive relief means. So we'll go ahead and talk about some examples here. Illegal activity happening on a property. So if there's, drug use and the smell is coming over into a neighboring property, any sort of noise pollution, light pollution, water pollution, odors, fences can be put in this category. Constant barking from a dog or, a bird that's very loud every single morning, any sort of animal noises, these types of things, and again, assuming they are both substantial and unreasonable, do rise to the level of nuisance when it comes to the civil remedies that are available. It can also include impeding a neighboring property's view of something. So if you have a view of the beach or the ocean or a conservation, for example, and somebody builds a third story on their house and blocks your view, it's not always going to fall into this category of nuisance, because again, we have to balance the offending property owner's right to build that third story or do whatever they want with their property with the neighboring property's right to the use and enjoyment of that view. So there's not kind of a hard line that we can put, well, if you block my view, you're guilty of nuisance and I can sue you. We have to look at the totality of the circumstances, consider all of the things that the courts have given us to consider when determining whether this constitutes an illegal nuisance or a minor annoyance, for example. So that balancing act is really the takeaway here, and is sometimes the difficulty in these types of cases. So to wrap up with nuisance, the difference between nuisance and trespass is nuisance is not a physical invasion of land, but it's an interference with a person's use and or enjoyment of their property, whereas trespass is going to be the physical invasion. Aside from that difference, our remedies are very similar, and how we would go about achieving those remedies are very similar, but that's going to be the main difference between the two. And let me take a look and make sure there is nothing in the chat. I don't know why it's not showing me that. Okay, we do have a question. So what about a buyer and the property is landlocked? So we're talking about landlocked property here. Have you had any luck with gaining access? What is the typical cost associated with this process? Thank you for the question. That's an excellent question. And it's actually an excellent leeway into the next topic, which are easements. So we're going to talk all about access, landlocked property, things like that. And then I will add in here, some information about the cost and what all is entailed in gaining that access. So we'll jump into easements with that. There are 3 different types of easements. So I'll go through all 3 generally, and then of course, as you have questions, make sure to put those in the chat for me. So the first one is the most straightforward easement, and that is an easement by express agreement. So this is 2 people, one person agreeing to allow the other to access their property for purposes of ingress or egress, or maybe it's for purposes of putting a utility line or something in the property buried underground, maybe. All different purposes. An easement is basically allowing somebody to trespass onto your property for a certain purpose. It's not an illegal trespass when there's an easement agreement, but it's allowing somebody else to enter onto your property for a certain purpose. So easement by express agreement, these are typically written agreements. They're recorded in the public record, so everybody, so there's public knowledge of the easement. And the easement agreement must contain all of the formalities of a deed. So an easement agreement must be signed with a notary and 2 separate witnesses in order for it to be valid. And then it's not required from a legal standpoint, but it's best practices to make sure that that easement agreement is recorded in the official records in the county where the property is located. So that's the most simple one. Because it is an agreement, essentially a contract between 2 people, these can look very different. There's some standard language that we typically include in easement agreements, but as far as who has to maintain the easement area, what happens if the easement area is damaged, all of the little details, those are worked out based on what the parties agree to and what the parties want in their agreement. There's no sort of standard or default that we have to follow when it comes to creating these easement agreements. So these can be very customized and tailored to the parties involved. The second type of easement is called an easement by necessity, and it's also called an implied easement because it's not expressed, it's not written down on paper, it's not signed off on by the parties involved. And this is where the landlocked property issue comes in. So since easements of necessity are not based on a written document that's recorded, when you go to sell property, you're probably going to have an issue with title. So a title examiner is going to be unlikely to be able to specifically note that there's an easement on the property, where the easement is, and what the purpose of the easement is, so what it can be used for. This can become an issue because now the buyer purchases the property and they see their neighbor walking across their front lawn every morning and they have no idea why. So the best way to go about easements is an express written agreement that's recorded in the public record. However, easement by necessity is something that has been created throughout the years in the law that is for addressing property that is landlocked or there's no way to access the property. We call that ingress and egress. Sometimes it's referred to as an ingress egress easement. So in order for an easement by necessity to arise, the land must either be used or desired or intended to be used for dwelling, agriculture purposes, timber, or for stock. Anything else, so commercial properties are typically not going to fall into this category, but residential properties that are landlocked, the law says that there is an implied easement in order to allow access to and from that property that is landlocked. So when we come across these issues, our course of action is, okay, property is landlocked, we need access. Let's reach out to the property owner that we need to agree to this access and see if we can execute an easement agreement and create an express easement. If that property owner says, you know, you can go fly a kite, I'm not signing anything, I'm not giving you access, that's when this implied easement by way of necessity comes in, and we can actually file a claim in court to force the neighboring property owner to allow you to access. Because although the law kind of creates automatically this easement by way of necessity, if the property owner that you have to go across their land in order to get access to your landlocked property, if they're not going to cooperate, they can put a fence blocking access, or they can do other things to block your access, and then essentially you have no way to get to and from your property. So sometimes it does take us filing a formal lawsuit to get public recognition, documented evidence, and a court order allowing that access and that easement to exist. So that is one way that we get these easements into written form and recorded, even without the cooperation of the neighboring property owner. We have a question that just popped in here from Randy. Who actually owns the easement and who pays the property taxes on the property? So an easement is not transferring or affecting ownership of property in any way. So the landlocked property owner does not have any ownership interest to the easement area. They have no liability for taxes on that easement area. They may have liability to maintain the easement area because they're using it, or if they damage it, they have the responsibility to repair any damage. But ownership and the obligation to pay property taxes does not change. So the person who owns the property where the easement is located is obligated to pay taxes just as they would if there were no easement there. Excellent question. Thank you for writing that in. So that is easements by way of necessity. The cost of establishing an easement by necessity can vary greatly because there's kind of two options. The first option I mentioned is we reach out to the property owner that we need to agree to this access and see if they're willing to sign an easement agreement. If they are, you're probably looking at between $500 and $1,000 to have the contract drafted, recorded, pay recording fees, all of that. That's the most efficient, cost-effective way to resolve it. If the property owner, the neighboring property owner is not going to cooperate and sign an express easement, and we have to file a lawsuit to get that established, that's when costs are really going to increase, and costs are going to depend greatly on whether the neighboring property owner is actually going to fight the lawsuit. Now, all that we would be required to do is prove in court that the only way to access the landlocked property is through the neighboring person's property. If we can prove that, we're going to prevail. Now, of course, you know, there again is this balancing act where we need to get access to this landlocked property, but we want the least amount of interference with the neighboring person's use and ownership and enjoyment of their property. So easements will be done in a way that we get the least amount of interference with the neighboring properties, property owners' enjoyment of their property. So if we can do it on, you know, through the back of the property that's not used as much, it's certainly not going to be through the center of the property, or anything like that. So all of, you know, that reasonableness test will come into play here as well, because again, we need, obviously you need access to your property and legally you're entitled to it if it's landlocked, but we also need to be, we need to take into consideration the reasonableness of the easement, the use of the easement, the location of the easement, as well as the neighboring property owners' use and enjoyment of their property. And then the third type of easement is called an easement by prescription. Sometimes it's referred to as easement by adverse possession, but the requirements for an easement by prescription and the requirements for adverse possession of property are different. So it's really not an accurate way to describe this type of easement. These types of easements are not favored by the law, and so there is a very high burden that must be established and proven before the law is going to enforce an easement of this type. So there are 5 different elements that are necessary to establish before an easement by prescription or prescriptive easement would be established under Florida law. The first one is that the user of the easement, so the person going through somebody else's property or land, has made a certain particular and actual use of lands owned by another. The second element is that such use has been continuous and uninterrupted for a period of 20 years. So here's where the first difference between easements by prescription and adverse possession comes in. Adverse possession, the use must be 7 year. For easement purposes, we're talking a span of 20 years. It has to be continuous use. So you can't say, well, I went through their property, you know, every day for 6 months, and then I didn't use it for 10 years, and now I'm using it again. That would be an interrupted use. Your 20-year period would basically have to start over there. Element 3 is that such use has either been with the actual knowledge of the owner, or it's been so open, notorious, and visible that knowledge is imputed to that owner. So you can't be at 3 o'clock in the morning sneaking around in camo gear through somebody's property without their knowledge and do that for 20 years and get this easement by prescription. You have to be doing it out in the open. Either the owner has to know about the use, or like I said, you have to be doing it out in the open in as continuously as necessary so that knowledge is imputed to the owner of the neighboring property. There's no way the owner could not know because the use is so continuous, uninterrupted, and open and visible. The fourth element is that such use relates to a certain limited and defined area of land, or if for a right-of-way, the use is a definite route with a reasonably certain line width and termini. So for purposes of a prescriptive easement, you have to be continually and without interruption for a span of 20 years be using the same portion of another person's property over and over and over again. You can't access your property, for example, down the left property line for one time and then go down the right property line and then go down the back. The use has to be in the same location, the same specific and usually very limited location on the person's property. And then the final element is that such use has to be adverse to the owner. So all that means is that the owner cannot be allowing you to use their property for that purpose. If they're allowing it, the use is not adverse and you do not get to establish an easement by prescription. So these are pretty difficult elements to establish. It obviously takes a very long time to establish an easement like this. And keep in mind that the law does not favor these types of easements. So it would have to be a very clear-cut, strong case on each one of these 5 elements in order for a court to recognize this type of easement. This is not what I would recommend you do if you are trying to establish an easement across somebody else's property. Usually these happen almost by accident. I thought there was an easement there. That's the only way I can access my property. I've been using it for 20 years out in the open. No one's ever complained about it. I didn't get consent, but I thought I was allowed, and I've been using it for 20 years. And so that's usually how these arise, is almost by accident. Let me see. Another question from Randy. Can a property owner include an easement into the selling contract prior to the actual listing? I've never seen it done that way. Whether it can be done that way, probably yes, but I wouldn't recommend it. And I'll kind of jump ahead in the presentation here, but most easements, especially express easements where there's a written document, they run with the land. So what that means is that if I sign an easement agreement with my neighbor, and then we both sell our properties to 2 third-party purchasers, the easement stays with the land. So all future owners of the property are bound by this easement. So my recommendation would be to have the current owners, so your seller and then the owner of the property where the easement is desired, go ahead and sign an easement agreement, record it. That recording will give notice to the title company and hence notice to the purchaser that the easement exists, and then the buyer can decide whether they want to close on the property given the easement or not. That would be a better way, in my opinion, a cleaner way to handle that issue. Joey has another question. What time frame is there for completing a lawsuit for easement by necessity? And what is the expected costs for such? So you're testing my knowledge here. I am not 100% sure on the statute of limitations for filing a lawsuit for an easement by necessity. It is definitely not less than 1 year. That's where our statute of limitations starts. But it also is going to restart with each new owner of the property. So if there's been no easement established and this property's been landlocked and abandoned for 20 years, you purchase the property and you now need to establish that easement, you can do so. You're not barred because the prior owner sat on it and didn't take any proactive action to establish that easement. But again, if the property is landlocked, you get your easement. You have to, if it's residential property or used for agricultural or the other categories that I mentioned, the law will grant you access somehow, whether it's the access you want and the location you want, I don't know, because it does have to be balanced with the least amount of interference of the neighboring property owner. But you're not going to run into a statute of limitations issue when it comes to landlocked property. Expected costs, again, those can vary a lot. So I would a very ballpark estimate for a lawsuit. If it's not contested, I would say you're looking about the $5,000 range. If it's contested, you can be looking at the $5,000 to $15,000 range. And that's on the high end. Typically these things get resolved for much less, especially because it is an easement by necessity and the law is so clear in that area. One thing that I do is I educate the neighboring property owner about the law and say, we can do this the easy way or the hard way. Either way, the result's the same. You get to decide how long it takes and how much money it's going to cost both parties, sort of thing. So those are all things that factor into it. Like I said, if we can get it done by way of agreement, that's usually going to be under the $1,000 mark. And this is all assuming, you use my firm with my prices. I don't know what other lawyers are charging for things like that. So big caveat there, but that's a good range that you can kind of expect. Something else that comes up with when we're talking express easement agreements and even easements by way of necessity, a lot of times when we approach that neighboring property owner and we say, hey, will you sign this? We need to use your property to get access to mine. They'll say, sure, I'll sign it, but you're going to pay me to be able to use my property. That's something that we do pretty often as well is we'll offer some sort of compensation to the owner as consideration for them signing that easement agreement with us. And you can look at it as you either pay it to the neighboring property owner or you pay it to your lawyer to go file a lawsuit and get you the result that way. Usually it's going to be more cost effective to offer some sort of payment to, and it's usually pretty nominal, to the property owner as consideration for agreeing to that easement. Let me see, make sure there's no other questions on that. Okay. So I will just wrap up here. I already addressed kind of one common question that I get is, does an easement affect future owners of the property? Generally, yes. So every time we do an express easement agreement, unless the parties don't want it for a particular reason, we'll typically include language that easement runs with the land, which means it does affect future property owners. Easements by way of necessity, if they are established by a court pursuant to a court order, almost always those are going to run with the land as well, because the next property owner is going to have the same exact problem. So usually yes, unless the easement agreement says something to the contrary, or it's an easement by way of necessity, and it's not formalized or formally entered by a court pursuant to a court order. When we're talking prescriptive easement, so the 20-year use requirement for prescriptive easement, that 20 years does get cut off with a change in title. So it has to be the same person, the same owner using the property for 20 years. Once the property sells, unless there's an agreement to the contrary, that use or that 20-year span is going to have to start over. I'll wrap up here with maintenance requirements for easements. That's another common question that we get. With an express easement agreement, we can memorialize what the parties want as far as maintenance goes. So whatever the parties agree to is what we put into the contract. Typically, the person in need of the easement, in need of using the other person's property for whatever reason, is the person who's going to be responsible for maintaining that area and for repairing any damage. However, that's not always the case. I've seen property owners that are very particular about how their property is maintained and they want it to look a certain way aesthetically. So they will agree to maintain it, but usually any damage is going to fall on the user of the easement. With easements by way of necessity, damage is going to fall on be the responsibility of the user of the easement as well. So maintenance can kind of go either way. That's why, again, it's best to have an express easement agreement, because the parties can specify who they want to be responsible for what, and that helps us to avoid any disputes down the road. That went a little bit longer than I had planned and expected, but there's a lot of great questions. Thank you all for participating in that. That wraps up my presentation on our topic for today. I'll go ahead and open it up formally for questions and answers. If you want to unmute yourself and ask your questions that way, that's perfect. If you want to put them in the chat, just as a reminder, the questions do not have to be about my topic. I'm here to answer any real estate related questions that you may have today. That's what these are for. So feel free to go ahead and ask those questions when you're ready. Let me just recheck. All right. And we'll give a couple of more minutes for questions. If there are none, we can go ahead and wrap up, but I do want to give an opportunity for questions before we do that. While everyone is thinking of their questions, we do have a very, very, very big announcement that we will be releasing this Friday. If you follow us on social media, we've kind of teased the announcement a little bit, given some hints, but haven't disclosed what it is. If you don't follow us on social media, you should be. We are on Facebook and Instagram pretty regularly. We also have a YouTube channel. And side note, these Get Real, we are recording these and we do post those on our YouTube channel. So if you ever miss one, or if there's something you want to go back to and listen to again, those will be available on our YouTube channel. But keep an eye out, stay tuned on our social media accounts for our announcement on Friday. It is very big. We have asked for guesses as far as what the announcement is. And I will tell you here, nobody has guessed it yet. So if you have guesses, let us know, but otherwise just stay tuned on Friday. Jennifer has put our firm email address in the chat, so if you need to contact us for any reason, that's there. Other than that, it doesn't look like there are any other questions. So Jen, if you want to go ahead and wrap up, and then if questions pop in the meantime, we can jump back into those as well.
All right. With that, I would like to thank everyone for attending this month's Get Real with Attorney Martinez, and wanted to remind you all that we will have an in-person offering next month, as well as the ability to have this meeting over Zoom also. It is the first Wednesday of every month at 10:30 a.m. And the next month's topic will be deconstructing the Florida Land Trust. And thank you all again. Have a great week.
All right, thank you all for attending and for the questions. I appreciate it. We will see you all next month.